My name is Joanne Geer. I'm the Executive Director for the Westchester Biotech Project, and we're just about to start our webinar, Timing is Everything, Virtual Roundtable on Intellectual Property. We'll be hearing from Scott Locke, and we'll do a short presentation, and then Chris Palermo will be joining in the conversation, and we'll be looking forward to your questions as well. I'm going to introduce my partner. This is Michael Welling.
Good morning, everyone, and thank you for joining us today. I'm not sure where you are all located, but I'm happy to say it is a gorgeous, beautiful day here in New York, so hopefully wherever you are enjoying the same. Today we have the second in our installment of our Intellectual Property Roundtable, and I'm really excited about the conversation that we're going to have today because I think it leads in so beautifully to our upcoming event next week around the rare disease space. Intellectual property is a critical component to any initiative or effort in this biotech field, and we are really fortunate to have Scott Locke from the law firm of Dorf and Nelson leading us today, and Chris Palermo, senior counsel from Harris Beach, contributing to the conversation around when is the right time to protect your IP and what are some of the pitfalls with that decision. Again, this really is a great launching point to some of the additional conversations we'll be having in the near future. So for anyone who's with us today, if this is your first time joining us, we hope it will not be your last. So thanks everyone again for joining us. Thank you, Scott and Chris, and I will turn it over to you.
Thank you, Michael. This is Joanne Geer again, and I'm just going to share a little bit with you about our organization. I love this quote from Dr. Carla Romney, who is the co-chair of our Roundtable for Educators and Employers, and a great supporter of ours. As Michael mentioned, next week we'll be holding our Rare Disease Symposium at Iona College. Just want to share with you, you can reach us in a lot of different ways. We love to talk to you on LinkedIn or Facebook. We have a YouTube channel, which is where this will be posted. And we are at Westchester Bio on Twitter. One of the things that we talk about a lot is building opportunity density for our region. So we're based in Westchester County, New York, which is just north of New York City. And there's incredible resources here. Many colleges and universities, hospitals, companies large and small. And yet it's largely, it isn't tapped. I won't say it's untapped, but it's not completely tapped by any means. And so a lot of what we do is look for people who in the region who can really contribute to building the whole matrix of everything a life science company needs. And we focus largely on researchers, engineers, and data scientists. We run a number of different programs. Some of them are ongoing programs, some of them are individual programs, and a lot of this is on our website, so I'm not going to go into any detail, but wherever you are at, it's very likely there's something that we can get you involved with. And one of the things that we found very early as we started our launch a little over a year ago is that everyone in our region is collaborating with someone else across the country and across the globe. So we are very interested in national and international collaborations. We have been blessed with support from many different sectors, from the county government, from wonderful law firms, universities, Skanska, which is a major builder, does a lot of laboratory and hospital building. 360 Pharma Solutions is one of our new partners. Bio Inc., which is an incubator at the New York Medical College in Valhalla, My Green Lab, which is a really interesting organization based in California. Harrison Edwards has been helping us with some of our messaging and so on. So we're really appreciative of all the people that have helped us to grow. I mentioned earlier, please please be sure to enter your questions in the chat box. We're going to have a little bit of presentation time, and the questions we'll handle afterward. And we have a small enough group today, we may invite you to open up your microphone. But for now, just please plan to put your questions in the chat box. And now we're going to transition to Scott.
Can everybody see?
Can't
Great.
see.
Well,
We can't see yet. We can hear.
okay.
You might need to share your screen.
It should be shared. Chris made me the presenter.
Right, but there's another thing right here to share your screen.
Yeah, we did that already.
It's so great before.
Yeah.
You're gonna have to do it again.
You know what? This is Chris Palermo. So, and I'm the moderator of this, and I think while they're dealing with the logistics of transferring the control over the PowerPoint to Scott, I'll tell you a little bit about Scott. We're very lucky to have him on the call, and he is a partner and chair of the intellectual property department at Dorf and Nelson, and Scott has a great deal of experience in this particular area. He's counseled clients on cutting edge issues across many different disciplines, including biotech, life sciences, pharmaceuticals. He's drafted, filed and prosecuted hundreds of patent applications, and he's written extensively. I won't attempt to summarize all of his writings in this area, and he has actually been an adjunct professor on the very subject of biotechnology and the law, and counseling startups on intellectual property issues, which he's lectured on for years in different universities. So he is a true expert in this area. And again, for those of you who don't know Scott, we're lucky to have him with us today.
Thank you very much, Chris. So why don't I get started while Joanna's loading up the slides, and we'll catch them up to where we are.
Okay. Hang on just a moment. I want to make sure everybody can see my side. So Chris Counsel, we need to work again to make either me, I'm the new presenter, great. I'm going to share my screen, and I'm going to give you my screen. You can push the buttons.
Wonderful. Okay. So let's get started after a small glitch. I'll start talking about the first slide, so we'll keep it moving as that one's going. So as we're going through and discussing patent strategies for today, there are 4 things that would be very helpful to keep in mind, and these are the 4 things that I like to speak to new clients about, or people when they have an idea for a great invention. The first is to figure out where you are in the process, which means, do you just have the idea? Have you tested it? Have you thought how broad it is? What do you need to get to the next level to show that your idea or your invention is going to work? The second issue is a financial one. Where are you economically? What do you need to get to the next level? Where do you need the money? Where do you need the patent to show you're entitled to money? The third is the landscape, because patents don't exist in a vacuum. What you are doing, other people may very well be doing the same or similar things, and there's a race to the patent office. The fourth are your contractual obligations, because most new companies start with people who have other jobs or come from other jobs or have other obligations. And we're going to talk through each of these this morning very briefly. So we're on the same page. Just wanted to kind of run through what the benefits of a patent actually are, because it's kind of a black box to most people. On the one hand, it's a legal right. So you can't have a patent unless the United States Patent and Trademark Office says you can have a patent. There's no right to your invention until you go to the patent office. So if you hang out and you wait too long and someone else gets there first, generally they win. The second really important point that very many people, including most members of the bar, get tripped up on is that patents don't give you a right to do anything. They give you the right to prevent the competitors from doing something. So if you have a patent on a complex formulation, if someone else has a patent on the active ingredient, you can't sell your formulation without a license from the first group. And vice versa, they can't sell the formulation without a license from you. The picture is just an example of the patent that Abraham Lincoln has, because I like to give people a little information in case you're ever on Jeopardy. And he's the only president ever to be awarded a patent. It was for boats and getting them over rocks and things in the water. The other view of a patent is that it's an economic asset, which is the most important to all of you who are not lawyers, is that it makes your company more valuable. And it's just like your car or your stock. You can sell it, you can assign it, you can license it, and the bank or your lenders can take a security interest in it. So it's really important to think of it as just an asset, because that will tell you how you want to cultivate it and what you want to do with it. Again, kind of set as a baseline for what it means for something to be patentable. And there are two different ways to think about this. The first is the invention itself. It's got to have some type of use. If you think about it, in theory, you could list all the possible molecules and combinations there are and run to the patent office and say, well, okay, I could use them just as a doorstop. But that's not really a use. So you've got to get over the threshold. This isn't hard for most people, but it's something to keep in mind. The second is that your patent has to be new. Your invention has to be new. So if anybody has done this before and it's been disclosed to the public, it doesn't matter where, you can't have a patent on it. So you can't repatent, you can't renew your patent. It's only for what's new and what's given to the public. It has to be new worldwide. So if it's in a student thesis in a library in Korea, if it's accessible and the patent examiner finds out about it, she's going to reject your patent. The third issue is it has to be not obvious over what's out there. So it can't be very close to what the person did before you. If you're increasing your concentration by 10% in your formulation, it's a fairly obvious thing to do in general, because a little bit more generally works a little better. The fourth one, which is very important in the biotech space, is it has to be patentable subject matter. If you remember a few years ago, there was a big patent dispute over the BRCA1 gene and whether you could actually have a patent to a DNA sequence because it exists in nature. And the new standard now in this country is that you can't have patents to things that are in nature, but if you tweak them at all, they become patentable subject matter. So you couldn't get to the DNA stretch as it exists in nature, but because the cDNA wasn't in nature, they could get a patent to that. And the same thing happens as we're working now with Cas9 and working with the small RNAs. If they're not in nature, people can get the patents on it, and they've been doing that for about 20 years. The other half of the patent equation is what you have to do in your application. So you have to be able to teach someone how to make the invention, how to use the invention, and what the best embodiment is of your invention. That's the quid pro quo for you getting a patent. You disclose it to the world, so 20 years later, everybody else could use it. This is the more interesting thing as you're starting out your companies or you're building your companies. If you go across the horizontal line, for those of you who are inventors, and I think about half of you are, you know this process. You think of the invention, you prove it, you optimize it, you figure out the best way to do it, the temperature, the size, the viscosity, whatever you might need. And then you try and expand it for additional uses. Now, on the top set of arrows, you got to think about the funding. When do you need funding? At which stage to get to the next stage? Right? You could need funding just to prove the experiments, or you may have enough resources to do that. You may need the funding to expand the experiments. Again, it's to move on to find additional uses and later to commercialize, which is not on the screen. The bottom row is about possible times for when you can go to the patent office. One thing to keep in mind is you don't actually have to have built your invention to go to the patent office. There are plenty of what we call paper patents, people who describe how to make the invention, and that's enough actually to get your patent done. You run the risk that you might not have proved it and tested all the variables, but you still can get a patent that way. And at each one of these intervals, you need to consider, am I ready to go to the patent office? In general, in the biotech field, people are not ready when they just conceive of the invention. But as we move into the bioinformatics space, a lot more things are done theoretically. So you are seeing the trend to people do that a little more frequently. At a minimum, though, most people prove the invention because they also want to make sure it's worthwhile because there's an expense with patenting. But as you know, each one of these takes time. And as the longer you wait, the more likely the competition is getting closer to what you are doing. So as you're thinking about when to file, because that's really the crux of today's talk, there are two competing forces, and you have to find the balance for your business. On the left side, you've got the idea you want to get to the patent office early because for all intents and purposes, it's a first to file system. Small ways to get around that in the US for circumstances that don't come up too frequently, but certainly in the rest of the world where most of your money is going to be made, first person wins. And that's it. It's not that I thought of it. I have my lab notebook. I can show that I did it first. That was old. That was about 20 years ago we were doing that, but the system now globally is get there quickly. So that's an incentive to move fast. The other reason is you risk disclosure. The longer you wait, the more likely someone is going to let it slip, even with the best of intentions, what your invention is. And if that slips and it appears on the internet or in someone's journal article, you lose. It doesn't matter why it slipped. It's an absolute bar, and the patent office doesn't care who did it or whether they had an agreement with you not to do it. The third reason is that your investors are going to want to see patent filings. It's very rare an investor is going to put money in a company that doesn't have a patent position, and can speak about it. On the flip side, you want to prove your invention, because you can't, if you go to the patent office too early, you can't fix or amend what you file. You have to do a new filing. And you only get the benefit of the filing date of what's on file on the day you put it there, which can sound kind of strange, but there's no putting things off. It's locked in time because you file day 1, the competitors file day 10. If you wait till day 30 to add another application, you can lose to them. So you have to balance it. Again, you want to fully develop the invention, because if you only show one use, you might not be entitled to the whole genus of uses that you may wish you could. And again, there's some balance depending on what field you're in of how much you have to show to get a breadth. The third thing is the cost. In the process of inventing, the process of patenting, it all takes money. As you're going to the patent office, there are a few things to do before you file, and this is kind of my checklist for people. You need to think about your obligations to third parties. If you are working 2 jobs, you need to realize that what you do on one job may be owned by that employer and not what you're doing in your startup job. You have to check your obligations, any contracts you signed, and you want to make sure that you're not using your current employer's equipment, resources, their time as you're building your new business. You might have obligations to your past employers. You certainly will have obligations to business partners. If you're doing a joint venture, you're going to want to figure out ownership beforehand. And the fourth one is the buy-dole obligations. And if you have any federal funding, particularly if you're affiliated with a university, you're likely to have this. You can't go to the patent office until you've checked with the funding office. So you have to check with NIH before you go to the patent office. If you make a mistake along the way, they can pull it back, which the Army has done a few times for people who are funded by it. The last issue is the foreign filing license. A simple, easy rule is you do not want to file abroad until you've got permission from the United States Patent Office, because that too can invalidate your patent. They do security checks. They're part of the national security vetting. So what do you do when you have the idea and the invention? And these are 5 things to think about when you're doing your strategy. The first are the non-disclosure agreements. Some people call them confidentiality agreements. In general, I recommend if you can get people to sign them, that's great. The thing to keep in mind, if somebody breaches your confidentiality agreement, that only buys you a lawsuit against him or her. It doesn't get your patent rights back. So the best agreement is only as good as the pockets of the person who signs it. So you want to be careful, even under confidentiality, who you share things with. The next issue is the provisional patent applications. This will get your stake in the sand. These are applications you file at the patent office. Sometimes when you're thinking about whether you're going to actually take an invention forward, but you want to get your stake in the sand. It can be a nice balance. Most companies in this field do this. One additional benefit of it is that it takes the last year of the patent out 1 year. For pharmaceuticals, that's really important because your last years are worth much more than your first years when you're still fighting with the FDA. A third strategy is some people have lots of inventions, and it's okay to put them all in the same application because the patent office will just divide them up, but you still get your stake in the sand. Another issue to think about is your foreign markets and your foreign rights. It's something to keep in mind, but as you're doing the patent process, there are treaties in place, so you don't have to worry about them day one. You get a year before you need to think about that. So it's a nice way to defer costs. And the last thing is to know the landscape, because as great as an invention is, if it's crowded or someone is creeping upon it, it's not worth a lot of money, and the people who are going to invest in your company are going to know that very quickly. So you want to think about how you use your resources. Chris, I'm going to turn it over to you.
Great, thanks, Scott. I thought that was a very useful perspective and overview for this audience. I would say to everybody listening, feel free to chime in. Some of you are well known to us, but we're certainly happy to have questions from any of all of you, and you can enter any questions you have in the chat space, and we'll get to them. I guess, Scott, first question. I'm an inventor, and I don't really know much about the law, but I've got something, and I think it's something that's worth pursuing. What's, in your experience, what's the biggest mistake that somebody in that situation makes in terms of what they do on the intellectual property front, steps that they actually make that in hindsight they wish they hadn't?
Thanks, Chris. So one of the things I see frequently is, for all the excitement of invention, and most inventors are very, very excited about what they do, they just want to talk about it, and they want to share about it, and they want to learn, and they want to build upon it. And the problem is, when you do that, it may help you learn more about your invention and its potential, but you could be shooting yourself in the foot in terms of patent rights, because whoever you tell it is free to talk about what they're doing. They're free to run to the patent office around the world. They're free to share with other people, to put it online, to discuss it in their articles. Again, once it's out in the public domain, in general, you lose, and at a minimum, it devalues your invention. So you really want to get to the patent office before you start talking about it any more than you absolutely have to.
And in terms of sharing information, it sounds like I'm better off, if I'm going to share any information, share my failures but not my successes. Is that a fair way to put it?
I think so. I think at least early on, certainly once you've got your stake in the sand, collaborate as you need, because I don't want the tail to wag the dog, but I do want you to be able to maximize the return on your invention.
Now, the flip side of my first question, what do you think is the biggest mistake that inventors make in terms of what they don't do that they should do?
I think that some inventors think too narrowly about their invention. And if you think of it as an archery target, a lot of inventors think of the bullseye. And what you really want to do is push yourself to think out to the white zone, because you want that zone around your invention to prevent people from coming close. And then the patent application, we can do the progressively narrower fallback positions, but you really want to think about, well, what if I did this, or it could also be used for? So if it's the new molecule you've invented, what can you do in terms of other applications, other therapeutics?
Now, suppose I'm in a situation where I'm doing research and I'm about to take this opportunity with a major research university, but my research is coming along, and if I can avoid it, I'd like to avoid entering into an agreement that creates problems with me, entering into an employment agreement that creates problems for me with any inventions I might come up with. Is there any real leeway on that front in terms of negotiating those types of agreements so that you aren't bound by a prior employment contract?
Going in, you can do it. By the time you're leaving the prior employment, it's too late, unfortunately. And most people just sign the agreements and don't think about those provisions, unfortunately. But you do, before you take a new job, want to read those very carefully, particularly if your job is with a university, because they have very strict rules about what they can and won't allow you to do, but every university is different. I see there is a question, though. I don't know if everybody can see the chat room. That says, can you offer any guidance about how to collaborate with another researcher while protecting your patent rights? So if you are collaborating with another researcher on an invention, that other researcher is likely going to be a co-inventor. And if that person is a co-inventor, then you have to go to the patent office naming both of you. You can have a contractual obligation as to who's going to own the invention, who's going to own what percentage of it. You can have a licensing deal with this person. You can buy his or her rights outright. But in terms of the patent law, they are likely the co-inventor. If they are just optimizing, they're just running the tests, so almost like a lab tech who's not doing the cognitive conception of it, but is pouring, mixing, watching, those type of things, then in general, you want to have a written agreement, but you want to be very clear that they don't own anything. You always want ownership in writing, because good fences make good neighbors, because the fight down the road only happens when your invention is worth a lot of money. But most people who you pay, particularly if they're assistants, like grad students, they'll take the money up front and go with it. And if you're in the bioinformatics space, it's very common for the computer programming people at the universities to do this. And they're relatively inexpensive, or reasonably expensive.
And then Scott, there's another question from Keith Safian. What are the costs to apply for a patent and the total cost to obtain it? Can you talk a little bit about the expense side of the application?
Yeah, sure. So in general, you're looking at somewhere in the $8,000 to $10,000 range to file your first application. Your US process, it depends how much resistance you meet, but it's not uncommon for it to run in the $20,000 to $40,000 range over the whole process of obtaining the patent. And then this happens in each foreign jurisdiction as well. There is some economy of scale when you go in the foreign jurisdictions, but you still have those costs repeating themselves, with the idea that Europe is in general one jurisdiction for patent purposes. And the UK will stay in that system despite Brexit, because the patent treaties are outside of the European Union. The next question is, can a patent be owned by an entity and or a group of people if they're only a group formed purposely to register the patent? Patents can be owned by any legal entity. It doesn't matter their purpose, their intent. Unlike trademark rights, you don't have to use a patent for it to be valid. You can have patents that just sit around, which, if you are old enough to remember, there was a whole problem with the patent trolls, these companies that would sue people, particularly in the computer and information technology space, who didn't actually do anything but just sue the patents. You are allowed to do that. It is legal under US law. So an LLC, an LLP, an individual. I'm just jumping through the questions.
So if you're reasonably confident your invention is under wraps without much risk for disclosure, should you continue to file new provisional patents every year?
I know many companies that do that strategy, that they're still developing it and they just refile their provisional applications. You certainly can do that. The risk is someone else. And there's that theory that lots of people work on the same idea all around the world at the same time. And that very often happens. So I've rarely seen that turn out well for the people who do it. If they're trapped once, maybe, but repeatedly, in the end, you're most likely going to lose on that.
Let's see.
That's the one we just did. I'm going to the next one. In reference to pharmaceutical.
To mention bioinformatics, the next one, can I patent the process by which I mine data and or the results of that search, even if I do not own the data itself?
The short answer is yes, you can do the process even without owning the data. The challenge is you can't do if it's too abstract what you're trying to patent, I'm going to go look at the pharmacies for a type of data and I'm going to cross-reference it to teenagers between 16 and 18. It's too abstract and the patent office isn't going to let you through. If you ever read the New York Times, that's the non-patentable subject matter because it's an abstract idea. As you get narrower and narrower, you're more likely to get through the patent office. So if you describe the algorithm you're going to use specifically, the problem when you do that is that it's very easy to design around. So the value of the patent isn't so great. What people are doing as a matter of course in the field now is that they're keeping that a trade secret. 20 years ago, the pendulum was the other way, but for right now, it's because of the way the law is being interpreted. People generally do not go to the patent offices with those type of processes unless they can tie it to something that's revolutionary or specific. There was a question about in reference to pharmaceuticals for the filing the patents every year, but it applies to that as well. Pharmaceuticals may be the one area where it's a little more beneficial because you've got the FDA lag time, but you still run the risk. If you're looking at a common target or you've got a molecule that's a likely lead, other people are going to do the same thing.
Can you talk a little bit, Scott, about the FDA lag time and how that impacts the patent process? You referred to it earlier. Sure. In terms of the timing and the value of the patent at different points.
Sure. So the FDA, which is the Federal Drug Administration, and the Patent and Trademark Office talk very, very little. And they're really separate tracks. You can do either without doing the other. Your patent, the whole point is you want to lengthen the term of your exclusivity. So by a patent, you get exclusivity to the invention. For an FDA, you get the right to market a specific molecule or formulation for a specific use. What happens is the FDA, if it's a new chemical entity, will give you 5 years of exclusivity, and you can tag on that for pediatric uses. And then for new uses of old compounds, it's a short exclusivity period. That gets issued whenever the FDA thinks you're safe and effective. And you go through your phase 1, your phase 2, your phase 3 trials. That can overlap with the patent office term. FDA term will expire 5 years from when they allow you to go to market. The patent will expire 20 years from your earliest filing date. On average, you spend 2 to 4 years at the patent office, so you're looking at about a 17-year patent period in general. So you can see those can overlap depending on how quickly you get through the FDA. Most people go to the patent office first because that's where they've got the most information, and they're not usually ready to go to the FDA before they're ready to go to the patent office, particularly if it's a new chemical entity, because you're trying it in the lab first and you can show use in the lab. The patent office will give you a patent on that molecule. The FDA won't give you obviously permission so you can prove it's safe and effective in humans. If you have delay at the FDA, that can be used to extend your patent term somewhat, but there's a limit on that as well. And independent of that, if you have unreasonable delay at the patent office will extend your term as well if it's their fault, if they don't respond to you in a certain amount of time that they're supposed to. And you'll get a patent term adjustment, which can be very valuable in the biotech industry. It can be years on the end. So people do make a big deal about that because every day can be worth millions of dollars.
Here's another question. If my intent is to repurpose an existing drug in hopes of treating an untreatable rare disease, what steps must I go through to obtain permission?
So the permission from the FDA you need to use, which you can go a little faster because some of the safety is already shown, but you've got to get through the FDA hurdles. When you go through the FDA in terms of the patent world, it's called the Orange Book. So for certainly if you're a generic, you have to go through the Orange Book, which is where patent holders list their patents, and you have to check whether that patent is going to affect what you do. And this turns into the paragraph 4 litigation that you may read about, where the pioneering company sues the generic before they go to market. But you still have to prove the same efficacy. Safety is a little easier when it's a new drug, when it's a new use for an old compound. The patent office will let you get patents on new uses for old compounds. You definitely can do that, and those patents are the same value as other patents. You won't get a patent on the chemical composition because it's the same composition that's known before. But if it's only been taught to be used in Alzheimer's, but you figured out how to use it for autism and no one suggested that, then you can get a patent on it subject to the standard that it wasn't obvious over what's already out there.
So I would say these questions that are coming in are hugely helpful because it helps us get a sense of where people are and what they're particularly interested in. So anybody who has them, don't be shy about asking them. One possible takeaway from the presentation in terms of timing, it might be that if you're gonna err, you want to err on the side of filing too early, because while that might hurt you, it doesn't prevent you from having any rights. Whereas obviously, if somebody beats you to the patent office, you're stuck.
Right, and you can, as someone had noted, file once a year. But another strategy that certainly larger companies do is that over the first year they file multiple provisional applications, and then they roll it up into one omnibus application at the end of the first year. And there are some complex procedural things that we do, but nothing for you need to worry about. But it is a strategy that people do. So as they're inventing, they'll add 3 paragraphs to the application, refile it as another provisional, so the economy is there because you're not writing a whole new application. And again, no one substantively is going to examine the provisional applications. Another question is, how well developed
I was just going to say, here's another question.
needs to be for you to claim rights in it. For example, how little validation can you get away with if you're trying to claim broadly and support additional applications? So it depends how new the field is, what you're doing, how predictable or reliable the data is. If you're in a traditional chemistry application, things happen fairly predictably as you go down the periodic table and you substitute elements. The predictable results happen frequently. So if you do, the element in the first row of the halogens and you start claiming a compound with the second and third halogen, the Patent and Trademark Office is comfortable with that. Biotechnology is a little more unpredictable. So to get broad patents in the United States, they usually require you to show diverse examples. So if you're claiming, for example, a molecule with the R groups, a strategy is people list all the R groups under the sun, but the less predictable each new R group is, the less likely you're going to be allowed to have a patent that broad, and you'll be forced to narrow it. So if you show for the ethyl and methyl, they'll probably give you the propyl and the butyl, but as you start adding the amine compounds and compounds with highly functionalized groups, you'll start getting more and more questions if you don't have data to show that it's all together and that you had that invention within your grasp at the time. But again, the strategy, you do fallback position. So you shoot for broad, and if you have to fall back, you do. The patent offices around the world are a little different, and some of them will allow broader rights on less data. So it is important to try for that because you can have different scopes of rights in Europe and the US. They don't have to be the same.
Scott, in terms of foreign rights and the expense, can you touch on that? You talked about the expense of going to the U.S. Patent Office, but if you were going to seek foreign rights in different places, sure, would they be roughly the same, or what would the overall cost be?
Sure. So let's walk it through the process so you can understand where the costs come in. So 1 year from your first U.S. filing, most people will file what we call an international application, which is really a placeholder for another 18 months. And the benefit of that lets you defer costs a lot because you want to avoid the translation costs, particularly for the East Asian countries. That filing, which then comes up at roughly 12 months from your first filing, you're talking somewhere in the $5,000 to $7,000 range. 18 months later, you have to decide which specific countries and jurisdictions you want your patents to go into. Not surprisingly, the bigger jurisdictions often cost more. Each one of those filings can run you anywhere from $4,000 to $14,000, depending on which country you're going into and whether translations are needed. So Europe is going to be a big one, but you're covering a big area, so it's one filing there. China and Japan, Korea are going to be costly because you have to translate into those languages. Canada, Australia, Israel are going to be less because you're in English. So there's not translation and the fees aren't quite as high. To get through those patent offices, it's not going to be quite as expensive as in the US in general because you learn from what happens in the US and you can often try for the same coverage. Some countries will defer to the US, some won't, but you're still going to be spending $10,000, $15,000 per other country, assuming that they meet only the same level of resistance as in the US. The next question is, how early would you suggest people work with an IP office to perform patentability assessments for them or do the assessments themselves? It seems it would be easy to invent in a direction that already has an obvious argument without even knowing it if you're not diligent. Do you see this problem often? So the question is directed to knowing what's out there before you go down the road. And I do recommend that people figure out what the landscape is so you at least have an idea of the low-hanging fruit that's going to be an obvious bar to what people are doing. Generally, inventors in this field have some handle on what's going on among their colleagues. So I do recommend that they do some type of searching out there, even if it's Google search, it's literature search from the popular journals as to people who are in there. It's beneficial in two ways. First, it helps tell you what not to do because somebody's already there, or if somebody's close, it helps you design around and to make your patent case stronger. So it is incredibly valuable to know. I recommend researchers do a little work themselves before they start paying other people to do it. You have no obligation to do a study, a patentability study, before you go to the patent office. But if you do one, you do have to share the results. You have an obligation to be honest with the patent office. This only happens in the United States, but you have a duty of candor, and everybody attached to it does. So save those results because they're important.
And when you say a patentability study, would that include something as informal as Google searches and the like?
Yes, if you know about it, and it might be, we call it material to patentability. So if it's relevant enough that you searched it and it comes up on your hit list as something that's relevant, that you're considering it, we need to tell it to the examiner. We don't make any admissions that this is going to stop patentability, but we give it to him or her so they can consider it, and you check the box that you're honest. If you don't do that, it can defeat your patent if somebody finds out down the road. You can be accused of fraud on the patent office. It gets really ugly. So I highly recommend you keep good notes and send them in.
And from the litigator's perspective, presumably, and that's my background, I represent pharmaceutical companies in various kinds of litigation, including IP litigation. In that litigation process, if you were involved in a dispute, would the other side have the ability to get the type of discovery to demonstrate what you knew internally, so that they can make a fraud on the patent office kind of argument?
Yes, absolutely. It's totally discoverable, and it's really uncomfortable to sit through those depositions because they're first going to ask you why you didn't tell somebody. But the good news is they'll ask the inventor and then they'll ask me. I don't get spared from that.
So Scott, I don't know, we've been going about 45 minutes. I don't know if there are other things you want to say, given the back and forth that we've had and the questions that have come in. Final takeaways from on this topic, or things that you'd like people to remember?
The one key takeaway is that the patent office is draconian and not forgiving. So there are some mistakes that you can't fix if you forget to do something. You get locked in time. So in triaging, particularly for new companies, you want to think about your patent strategy early and what you're going to do with it. There's some things in the legal world, because you know this, you can defer till later and aren't quite as important, but this is when you need to get locked down, and it's going to evolve over time. But if you make a mistake, sometimes those mistakes are fatal, and it can make a company worth significantly less to killing a deal.
Well, thanks very much. Joanne, I don't know whether you want to jump in here, and you have other questions, and obviously if people still have questions, feel free to ask them.
Well, I want to thank both of you. And there was a question I don't think came up yet. Is the provisional patent database searchable? No,
you cannot search provisional patent applications until 18 months after they're filed, if it's converted to a full application. So for the first 18 months, everything filed in a new patent family is confidential. There's no way to search that. So there is this black box. You can't know what everybody else is working on. It's an imperfect science. So even if you do a patentability search, it's not going to be foolproof.
Well, like many things in life, it's a fraught forest with no front gate, right? Well, this is terrific. I really want to thank both of you. This has been a terrific conversation, and I think we'll be wanting to do some more on different aspects. Do we have a new question? Oh, we have another question. Go ahead.
We do. The question came in with respect to the duty of candor. How far does that obligation extend? Is it limited to only those involved in the application, or to the other extreme of everyone in the company?
It's generally cited on to the people associated with the patent application. It becomes a gray area. It's certainly not expanded to everybody in the company, but there is a zone of what's relevant. So anybody with actual knowledge, so the inventors, the internal conduit who may be an internal general counsel at a small company, or the person who refers, certainly all the attorneys who touch it, whose name appear from outside counsel will be involved. But anybody who's involved in the obtaining of the patent rights, and I would say only one tier beyond that, I really have not seen people extend it broader. There is a reasonableness category level of threshold on this that it just doesn't make sense, particularly if you're at a huge company. I know we have people from some very large companies here. I've never seen anybody imply that it would extend to everybody in the company who doesn't have any association with it, particularly when you've got researchers across the globe doing many different endeavors. So I'm not quite so worried about scorched earth from the company's point of view when they're filing. It's really that first tier, but those inventors who are in general going to have the most relevant information anyway are the ones that if they get left out, it becomes a very big problem. How often does an initial application prevent future filings down the road? Is each an entity, or can the same authors file another patent that would infringe the first? How are new to? So I have seen many inventors have their first filings prevent them from obtaining later filings. It's an interesting dilemma because you want to put as much as you can in the first filing to get as broad potential coverage as you would like to obtain. But there's a difference between disclosing something to make it obvious as opposed to meeting the threshold of being able to get a patent on it. So you could list a million different possible combinations and permutations, but you still might not be able to get a patent on something because you haven't described how to make it or how to use it. But that, let's assume that's year one. 4 years later, you do figure out how to make or use it. What you described earlier on can be cited by the patent office against you to prevent you from obtaining that later patent. So you can prevent yourself from getting a patent. And often, particularly for scientists who have done a lot in their field, the first thing that the patent office cites is their own work against them. There's a second caveat: how are new drug structures from medicinal chemistry protected if a patent is already in place? So if it's a new drug structure, the old patent wouldn't cover it. But if it's disclosed in the old patent, let's say, and not in a patent claim, it's just something that's talked about, that would in general prevent the new patent on the new structure. You could still get it on the new use, and you can get it on optimized formulations of that structure. So if those formulations aren't obvious, if you're using your usual surfactant, or you're doing coating to make extended relief, those things are frequently common techniques, so you wouldn't be able to get a patent on that. But if you can combine it with other moieties or other active ingredients, people often use that strategy, particularly ones that for some reason people would not want to combine because of their functional groups or because of potential side effects, and you realize the synergy.
Scott, this is Joanne again. I'd like to talk a little bit about, so you have a PI in the lab who's getting through all these hoops. How should they talk to their postdocs who are actually doing the work? Do they have to keep a secret from them?
In general, no, but the postdocs are supposed to be educated on their confidentiality agreements or obligations, particularly to the universities, assuming predominantly in the universities. And most of them have policies, and as postdocs, different universities will make you sign as a condition of being a postdoc your obligations to them. I think any university that doesn't instill that in the postdoc will be once bitten, twice shy about that, but there are certain confidentiality obligations there. I've rarely seen the issue where the postdoc runs out quickly and does something behind their back. What often happens is the postdoc will go to a new lab and then he or she will build upon arguably what they learned in the first lab, and there's some ambiguity as to who actually owns that. And then you get into a very fine issue as to how far along the invention was when that postdoc left. Because did she go at day one, or did she go when we were almost fully done and she took that knowledge and shared it with somebody else? And you get into very nasty fights over that, very expensive ones, particularly if they're the big inventions. So, if it happened with the CRISPR, it would have been a disaster.
So this is a really interesting area. In our Young Investigators program, we really try to help people in the PhD postdoc part of their career to do things like come and present. We always like to have young presenter, someone who may have never presented anywhere before. You talk about what a typical permission process might be internally, whether it's a postdoc who might be at a university or maybe a fairly new hire in a large pharmaceutical company.
Sure. Usually, you're not allowed to disclose anything or make any presentations. In general, it's anybody at the university, including the professors, are supposed to clear everything, because that presentation of itself can ruin and destroy all patent rights. So certainly all large companies that I know of have a clearinghouse for it. And you've got to clear anything you want to send out, whether it's to a journal or to make a presentation to a Gordon conference or any other type of other university, or to your students, because they know very well. The universities are very savvy about this now. Their tech transfer offices have good formal processes to help guide everyone through them. Good from their perspective, unfair from the research perspective sometimes, depending on the university. The company too, so you are going to want to definitely follow the process. So you generally submit the slides, you submit the article to the clearinghouse person who will make an evaluation. And usually there's a fixed number of days that they're allowed to look at it. They have to tell you they need more time, or you can default to disclose it. But it's specific by company and by university.
I'm having a little bit of a flashback. For years ago, I was at a major land grant university and was talking to the person that was running the tech transfer office at 5 o'clock on a Friday afternoon, and he got a call from a professor in Zurich saying, I'm going to do a presentation tomorrow. You better file a provisional patent for me tonight. Let's talk about when a scientist should start talking to an attorney and figuring out all this process we've been discussing.
In general, the earlier the better, because the hard part is you don't know what you don't know, and you don't know what's going to trigger the ban. And one of the things is that scientists, a lot of them have the best of intentions and they want to share. And again, I think I mentioned this before, they disclose to people who they trust, but the people who they trust don't fully appreciate how important it is to keep the trust for their best of intentions. So the earlier the better. The earlier the patent office, when you're ready, that it's of value to get there, is, I think, as Chris noted, the side to err on, because you certainly want to do that. And again, for people who are still at the universities, for the grad students, you certainly want to be talking to tech transfer. The earlier the better, because some of them will give you authorization to say, we don't want it, do whatever you want with it, which can be nice as well, but you want to know that and you want to have that in writing, because you don't want to fight with the university again years later, because the universities are very aggressive in the courts, protecting their inventions and what's been invented in their labs.
Well, lovely. I'm not seeing any more questions. I think maybe we're coming in for a landing here. Chris, is there anything you wanted to make sure we say before we part?
No, and Joanne, I'm sure both of us appreciate your softball question as to when you ought to reach out to the lawyers. But I do think that makes a lot of sense in this area, because obviously the stakes are high and the consequences of making mistakes are substantial. So thanks very much, and again, thanks everybody for the questions that the audience put in for us to talk about.
That's great. Yeah, this has been a really good, lively questions. Our recording is going to be on our YouTube channel. We'll be sending a note out to everyone soon. Thank you. Thank you to Michael Welling. Thank you to Scott Locke. Thank you to Chris Palermo. And we'll see you next time.
Wonderful.